Hello and welcome to the Herrington Carmichael Employment Law Update for May 2016. I'm Alistair MacArthur, I'm the head of the employment team, and as always I've got a short update for you now on the latest key developments in the area of employment law in the last month. Let's start with the key case from the month, the Department for Transport versus Sparks. Now many of you will know that with employee handbooks you should try and avoid these employee handbooks becoming contractual. That allows you to amend them easily. Unfortunately for the Department for Transport, they got it quite badly wrong. They had a handbook which allowed for some of the terms to be incorporated into employment contracts, and when they came to change those as part of the absence management reporting procedures, they fell foul of that and found that they couldn't do so, and were actually caught out by the Court of Appeal in this case in the last month. So what do? Check your handbooks, make sure they're clearly not contractual documents. If they are contractual documents, come and take some further advice and we'll look to guide you through it. In the last month, the government have called evidence for whether business is being stifled by clauses in employment contracts, particularly looking at entrepreneurs looking to set up businesses and whether they are being stifled by potentially non-compete covenants in their existing employment contracts. Watch out for this. This is obviously a government initiative. If you do have contracts which have anti-competitive provisions in them, you may want to look to review those, or you may want to keep an eye on this development as it continues. Next, we've seen in the last month the Information Commissioner's Office prosecute a former employee for stealing customer data. That employee was stung for a £300 fine. This is an interesting position for employers because normally you wouldn't think of pursuing a complaint to the Information Commissioner's Office where an employee takes your data. However, if that's personal data and they have no right to that data, then there is a route of complaint there. It's one certainly we'll be looking at in the future. Lastly, what we've seen several reports on what employers are doing to conquer the national living wage. As many of you will know, from the start of April, the new national living wage is applied to workers who are aged over 25 with a new rate of £7.20 per hour. Employers are taking lots of different tactics to try and avoid increasing pay, and the way they're doing that is to either reduce hours, reduce additional benefits around the side. We've certainly had several clients asking us for advice upon the same issue, and if you're feeling the pressure under the national living wage, please come and talk to us. We'll be happy to help you review what you're doing. That's it for this month. If you have any questions, as always, please do let us know and we'll come back to you next month. Thank you very much.